free speech is perhaps the most frequently invoked liberty in the Bill of Rights. For the most part, Americans today can say and write what we want, and that includes the press. We can criticize the government without retribution, and many Americans are so skilled at it, they do it for their full-time jobs. Let's look at a few key concepts and some pivotal court decisions that have placed either limitations or protections on the freedom of speech and the press. But first, let's take a look at the clause in the First Amendment that talks about the freedom of expression. Congress shall make no law abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. This clause establishes our freedom of speech, freedom of the press, and our freedom to assemble. Prior restraint is restraint against actions before they happen rather than punishment after the fact. Prior restraint makes freedom of expression either impossible or punishable. Censorship of the press is one method of prior restraint, and the courts tend to view it quite critically. In the landmark case, New York Times v. United States, the Supreme Court affirmed the prior restraint doctrine when they allowed newspapers to print the Pentagon Papers in 1971. The Pentagon Papers were secret documents about the Vietnam War that had been stolen by a former Pentagon employee and given to the New York Times and the Washington Post to publish. The federal government claimed that publishing the documents would be a threat to national security, but the court held that it was the government's burden to prove that the publication of such documents would cause, quote, inevitable, direct, and immediate danger to the United States, unquote. The court held that the government had not done so in this case, and they not only ruled that the public had a right to see the information inside the documents, but also that the press had the right to share it with them. But not all forms of speech are verbal. The court has recognized nonverbal expressions, such as gestures, motions, and clothing, as symbolic speech. In the 1968 case, United States v. O'Brien, the Supreme Court ruled that a 1965 amendment to the Selective Service Act prohibiting the willful destruction of draft cards was not protected by the First Amendment because it interfered with the government's ability to maintain an efficient military draft system. However, a year later in Tinker v. Des Moines School District, the court would decide that wearing black armbands to school to protest the Vietnam War was symbolic speech that was protected by the First Amendment. Similarly, in the 1989 case Texas v. Johnson, the Supreme Court ruled that the 48 state laws prohibiting the desecration of the American flag violated the First Amendment freedom of expression. In response to this ruling, Congress passed the Flag Protection Act of 1989. The very next year in U.S. v. Eichmann, the Supreme Court also ruled that this law was every bit as unconstitutional as the state laws had been. Americans today are free to speak negatively with one another about our country. It doesn't mean that we don't love her, and it certainly shouldn't be prohibited. The authors of the Bill of Rights must have agreed because they made it apparent in the First Amendment. But it would take a while to define the First Amendment the way that we define it today. In fact, students are often shocked when they hear how many times our government has restricted the speech of Americans in ways that might seem unbelievable today. Criticism is a form of subversive or advocacy speech. But speech isn't always mere criticism. Sometimes it's dangerous, and depending on the circumstances in which subversive speech is made and the authority or influence of the person speaking, such speech can go beyond simply expressing thoughts and opinions. Some speech can incite harm, crime, and violence, especially if the speaker holds a lot of influence. So, how do we know, or should I say, how does the court know what is protected speech under the First Amendment and what is not, especially when we're talking about subversive or advocacy speech. The first legal standard on this topic wasn't established until 1907. That year, the bad tendency test was established in the case of Patterson v. Colorado, which held that freedom of speech can be restricted by the government if its sole tendency was to incite or cause illegal activity. This test would be the legal standard for about 12 years. The clear and present danger test was established in Schenck v. United States in 1919. During the First World War, Charles Schenck and Elizabeth Bear passed out flyers stating that the military draft violated the 13th Amendment's prohibition of slavery by forcing involuntary servitude on American men. Now, the flyers weren't just making a statement or expressing an opinion about the draft. They were urging American men to disobey the draft. But they did ask specifically for them to do it peacefully. Schenck ended up getting charged with violating the Espionage Act of 1917. He appealed, saying that the act violated his First Amendment right to free speech. But remember, this was a time of war, which was why the draft was necessary. And that's how the court approached this case. The court did two things that are relevant to this discussion. First, they ruled unanimously that the First Amendment did not provide protection in this case because the communication, the speech, could have hindered national security during a time of war by interfering with the draft process. In Schenck v. United States, the court held that during war, circumstances change. In war, the government's right to efficiently use its military outweighed the citizens' freedom of expression. The opinion was written by one of my favorite justices, Oliver Wendell Holmes Jr., known to write opinions that combined the logic of a scholar with language and metaphors that were easy to understand. In fact, you may have already heard the famous quote from this opinion in which he wrote, "Free speech would not protect a man in falsely shouting fire in a theater and causing panic." Holmes emphasized that in many places and in ordinary times, the defendants, in saying all that was said in the circular, would have been within their constitutional rights, but the character of every act depends upon the circumstances in which it is done. The second thing that the ruling did was to establish a new test for the courts to use going forward as the legal standard for determining if subversive speech is protected by the First Amendment or not. It's known as the clear and present danger test, and here's how the opinion defined it. The question in every case is whether the words used are used in such circumstances and are such a nature as to create a clear and present danger that they will bring about the substantive evils that the United States Congress has a right to prevent. It is a question of proximity and degree. When a nation is at war, many things that might be said in a time of peace are such a hindrance to its effort that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. But here's the thing. Justice Holmes didn't intend for the clear and present danger test to completely replace the bad tendency test, but that it would be used to further refine it, especially during times of conflict or war. Yet the Supreme Court, at that time under Chief Justice Edward Douglas White, continued to use the clear and present danger test as the only legal standard for upholding convictions of wartime prosecutions that resulted from the espionage and sedition laws that were passed during the war. You see, World War I was very unpopular with the public. The U.S. certainly wasn't the global superpower that we are today, far from it. We were an isolationist country until World War II, And even then, it took being attacked on our own soil to get Americans behind the war. Add to this the fact that the Wilson administration had begun a campaign for criminal prosecutions of some pretty trivial offenses violating the espionage and sedition laws. But it wasn't just the federal government. States were passing even stricter laws prohibiting criticism of the government. In one Minnesota case, a man was arrested and convicted for saying that a recent campaign asking Minnesotans to knit socks for soldiers was a worthless way to make people feel like they were helping support soldiers, but that in reality the soldiers didn't care about socks at all. They had bigger worries on their minds. This guy was arrested and convicted of violating the Espionage and Sedition Acts. I'm not kidding. This really happened, and it's just one of thousands of examples. Imagine if the government of 1918 could peek into the future and just read some of the comments on Facebook and Twitter today. There would not be enough law enforcement to arrest everyone. But as for Justice Holmes, who was known to frequently dissent with the court's majority opinion, he believed that the court later began to stray from the reasoning behind the standard he crafted in Schenck v. U.S., adding that the court had been allowing the punishment of ideas rather than the punishment of speech that caused a clear and present danger that was actually likely to happen. Holmes thought that the court began to lose sight of the fact that Schenck was trying to get people to avoid the draft, and that is why Holmes voted to uphold his conviction, not simply because Schenck was criticizing the government in general, but because of the likely outcome the speech would have caused. The third and current legal standard for subversive or advocacy speech protection is the imminent lawless action test, established in Brandenburg v. Ohio in 1969. In this case, a Ku Klux Klan leader who spoke at a rally in Ohio was convicted of violating a state law that prohibited people from advocating, quote, the duty, necessity, or propriety of sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform, unquote. The court ruled that the First Amendment does not allow a state to prohibit the advocacy of the use of force or of law violation except where such advocacy is likely to incite or produce such action. Since the court ruled that this standard was not met in this case, the conviction was overturned. The ruling established the imminent lawless action test, and it has always been a difficult standard for prosecutors to meet. As a result, the protection of advocacy speech and free speech in general in America was greatly expanded. The ruling overturned the conviction of the leader of an extremely unpopular hate group who said things that were terribly racist and bigoted and hateful. But, said the court, he did not say things that were likely to cause imminent lawless action. The court was not ruling for white supremacy. Rather, the court was saying that yes, even unpopular opinions, even what some people may consider scumbags, can freely express themselves as long as they don't violate this standard. But you have to look at this controversial ruling, even if you disagree with it, as free from moral judgment as possible and see beyond the circumstances of just this case. Instead, try and look at this ruling from a personal perspective, one in which the Brandenburg test might protect your own speech, especially speech that matters the most to you when it matters the most to you. So is all speech that doesn't incite imminent lawless action protected by the First Amendment? You know, can people just walk around anywhere they want and say anything they want about anyone they want, to anyone they want, regardless of how accurate the statement is. Well, you can certainly try, and there's a good possibility that you might get away with it. But there's also a possibility that you might find yourself on the receiving end of a civil lawsuit. Unprotected speech, or speech that is not protected by the First Amendment, includes slander, libel, some obscenity, and gag orders issued by a court of law. Slander is knowingly making false, defamatory public statements about someone out loud. And libel is knowingly making false, defamatory public statements about someone in writing. Although they aren't crimes, these are civil offenses that defame the character of someone. The court requires a greater burden of proof in defamation cases brought by public figures than it requires for private individuals. Public figures are people who are publicly well known. This includes elected officials and celebrities, basically anyone who's in the public limelight enough to substantially influence society. The court hasn't always been as open-minded about obscenity as it is now. It used to be common for state and federal laws to criminalize obscenity, even if these laws were quite vague when it came to defining it. In fact, it was only 100 years ago that some of the most revered pieces of literature were banned from even being published or imported to the United States. James Joyce's Ulysses, for example, was banned from being published in the United States in 1922 because it was considered to be obscene. This ban wasn't lifted until 1933. Compare this view of obscenity to what is freely accessible and expressible on the internet today. How did we go from banning modern literary classics in the 1920s to the age of internet pornography in 2020? In Justice Potter Stewart's 1964 concurring opinion, in which he attempted to define obscenity, he wrote, quote, "I could never succeed in doing so, but I know it when I see it," unquote. Not the most objective definition I've ever heard, that's for sure. Unfortunately, it would be another decade before the court would finally succeed at defining obscenity in the 1973 Supreme Court case Miller v. California. In the court's ruling, Chief Justice Warren Burger defined material as obscene if the average person would consider it so, if it appeals to a prurient or immodest interest in sex, and now, as for what was considered prurient interest, he said that that would be determined by state or local community standards. If it clearly displays offensive sexual conduct, and if it has no significant redeeming political, literary, artistic, or scientific merit. A gag order is a court order restricting public speech about a particular case. Now, when a judge issues a gag order, its purpose is to protect the integrity of the case, not to needlessly infringe upon the public's freedom of expression. Okay, last but definitely not least in this lecture is the freedom to assemble and petition the government for redress of grievances. This means that not only do we get to complain to the government and to one another about injustices or things that we think are unfair, but the First Amendment limits the government's power to prevent we the people from organizing together in person, peaceably, to put our free speech into practice. We can assemble together in public places and celebrate or protest alike. Perhaps this powerful right to gather together publicly in order to make our collective voices heard is one of the most powerful rights that we hold as Americans. After all, people can talk all day long and get nothing done. Real change happens when people show up in life. That being said, this liberty is not a free pass to terrorize or to riot freely. That's why the First Amendment specifies that protected assembly must be peaceable or peaceful, or it's not protected at all. The courts have placed the right to assemble on par with freedom of speech and freedom of the press. However, the courts have also held that it's fair for state and municipal governments to require demonstrators to obtain permits and things like that for group activities in order to provide necessary provisions such as traffic control and standby law enforcement in order to ensure things don't get out of control and disturb the safety and welfare of the public. Remember, one group's liberty to assemble should not come before another group's right to safety. Group speech is powerful, but so is the violence of an angry mob taking over public spaces, violently disturbing the peace, or especially interfering with the government's ability to carry out its essential functions. In the 1937 Supreme Court case, DeJong v. Oregon, Communist Labor Party member Dirk DeJong held a peaceful meeting to advocate for prison and labor reform in Portland, Oregon. Despite the lack of violence or unrest at DeJong's meeting, he was arrested and accused of inciting violence anyway. The state argued that even though violence wasn't on the group's agenda for this particular meeting, the Communist Labor Party had a track record of openly advocating violence to achieve its goals in the past. Therefore, it should be assumed that this meeting was no different. The court disagreed. It ruled that as long as DeJong was leading a peaceful assembly, he had the right to freely express his beliefs to the group, and the group had a right to hear what he had to say, so long as what he had to say didn't incite violence. The court held that peaceable assembly for lawful discussion cannot be a crime, and that making it a crime posed more of a risk to society than the meetings themselves, regardless of how unpopular the group's views may be. The next landmark case we're going to talk about is the 1978 landmark Supreme Court case, National Socialist Party of America v. Village of Skokie. And this will be the last case that we discuss in this lecture. So I saved, I think, maybe the best one, the most fascinating one for last. There's this super cute suburban town just 15 miles north of Chicago called Skokie. It's a really pretty, idyllic village, much like many of the other picture postcard communities throughout America. But Skokie has a distinctive population, or at least it did in the 70s. In 1977, Skokie had, and still has, a population of about 70,000 people, over half of which were Jewish at the time. Now that's a Jewish population of about 40,000 people. Of these, about 7,000 were survivors of World War II Nazi concentration camps. This was said to be the largest of such populations west of Israel at the time. Quite a distinction indeed. In fact, it was this particular demographic detail that attracted the attention of Frank Collin, the leader of the National Socialist Party of America, when he was looking for just the right place to hold a neo-Nazi march that year, complete with World War II-style costume-like Nazi uniforms, swastikas, flags, Nazi salutes, the whole bit. Collins' correspondence with Skokie officials emphasized that the march would be a peaceful demonstration in keeping with the First Amendment, But once word of the demonstration spread throughout the community, you can just imagine the variety of emotions and terror that this created among the citizens of Skokie, especially the 7,000 Holocaust survivors and their families. Imagine surviving genocide in Europe, fleeing to the United States to start all over, possibly after losing your entire family and all of your possessions. And you find yourself 30 years later in this idyllic village within the country who defeated Hitler in World War II, alongside 7,000 of your neighbors who suffered through the same nightmare as you. Besides Israel, it was literally the last place on earth that you would think you would run into a bunch of Nazis ever. Until you hear, of course, that this march was being planned. It was like a slap in the face to the community, a psychological assault on the Jews in Skokie. So when the backlash from the community developed, around 15,000 counter-protesters had planned to attend the neo-Nazi demonstration that itself was only supposed to include no more than 50 marchers. After listening to some of the statements that were made by Skokie Holocaust survivors, an injunction was issued by the county court prohibiting the demonstrators from displaying swastikas or wearing their Nazi uniforms and doing their whole demonstration. When the neo-Nazi leadership tried to appeal this decision by the county court, the Illinois Supreme Court refused it. But the United States Supreme Court took a look at the case and decided it without even hearing any oral arguments. They just relied strictly on the briefs alone, and they went ahead and issued a per curiam opinion on behalf of the entire court. I guess they decided that it was that clear-cut of a case. The court's ruling didn't decide if the neo-Nazis had a right to demonstrate in Skokie as originally planned, but that because the state courts issued their injunction before the neo-Nazis even had a chance to argue their case, they were going to overturn the injunction, and the Supreme Court returned the case back to the Illinois courts. So this was a situation that permitted the neo-Nazis to demonstrate in Skokie, Illinois if they wanted to. But they never did. They decided not to. After the case gained so much national attention, the city of Chicago offered to allow the group to hold their demonstration there in Chicago, taking Skokie out of the equation completely. Well, the leader of the neo-Nazis, Frank Collin, agreed to this, and the march was moved to Chicago. It's easy to defend the rights of people that we share groups with or that we agree with, but sometimes we have to defend the free expression of those we fear and loathe, because when we limit one group's right to peaceable assembly or free speech, we set a precedent to limit every group's right to peaceable assembly and free speech, including our own. As difficult as it may be, there are a lot of people and organizations that devote all of their time to defending the rights of people that they just so happen to disagree with. In fact, the lead attorney from the ACLU that represented the neo-Nazi group was David Goldberg, a Jewish man.